But unfortunately, it is possible in warfare that civilians will be killed. And actually, under the laws of war, that they could be killed lawfully because a military force will direct its attack against a military objective. But incidental to that, civilians may be killed, what the military refer to as collateral damage. And this is where the rule of proportionality comes in.
Powered by International Committee of the Red Cross.
Hello and welcome to another episode of Legally Speaking. I'm your host, Ayesha Malik. And in today's episode, we're going to be talking about the laws of war. Now, Cicero believed that laws were silent amid the clash of arms. However, the notion that rules were necessary, even in times of armed conflict, has ancient roots. So from the Vedic traditions to Sun Tzu's The Art of War, to Roman law, to the Bible, and also the Quran, all of these texts include stipulations of what is or is not allowed in war. These norms have evolved into the contemporary law of armed conflict, which aims to spare those not directly involved in hostilities and limit the effects of violence to the amount necessary for the purpose of war. These rules aim to balance between the need to uphold humanitarian rules, even in times of armed conflict, and that of military necessity, which would allow for a party to the conflict to engage in lawful conduct in order for it to win the war. Therefore, they really seek to inject some element of humanity into the awful business that is warfare. To talk to us about this, we have with us Mark Lattimer, who is Executive Director of the Ceasefire Centre for Civilian Rights. We hope you enjoy the podcast. So to talk to us more about the laws of war, we are very happy to be joined by Mark Lattimer, who is Executive Director of the Ceasefire Centre for Civilian Rights. Thank you so much for joining us.
Good to be with you.
So I wanted to start off by asking you if you could just explain for us the cardinal principles of the laws of war, so distinction and proportionality, and how they apply in armed conflicts.
Right. So I think it's useful, first of all, to say that war does have rules. I mean, a lot of people think about war as being the absence of rules, where almost anything is allowed. But in fact, almost since the start of human societies, war has always had rules. And now, two of the most important rules are the ones you just referred to, distinction and proportionality. So the basic rule is the rule of distinction. And that says that you have to, as a military force, you have to make a distinction between civilians and civilian buildings and other civilian objects on the one hand, and military objectives on the other hand. And you can only direct attacks at military objectives. So there has to be this fundamental distinction between the civilian and the military, and only the military can be targeted. That's the basic rule. But unfortunately, it is possible in warfare that civilians will be killed. And actually, under the laws of war, that they could be killed lawfully because a military force will direct its attack against a military objective. But incidental to that, civilians may be killed, what the military refer to as collateral damage. And this is where the rule of proportionality comes in. And basically, this rule says that attacks are prohibited when the expected civilian harm is excessive in relation to the anticipated military advantage. So if basically the damage you're going to do to civilians or civilian objects is excessive in relation to the military objective or the military advantage, then you cannot go ahead with the attack. So in this way, the laws of war, they underscore the basic rule: you can't attack civilians, but they do allow, through an understanding of military necessity, that sometimes, unavoidably, civilians may be harmed.
So when we're looking at it in the context of conflicts, such as the one that Israel is waging in the Gaza Strip, one of the key issues has been the notion of proportionality. And we've had American military commanders come out and write for publications like The Atlantic, such as Phil Larkin, talking about how the non-combatant cutoff value, so that collateral damage level, is incredibly high compared to other wars waged, including those by the US against ISIS and in Iraq. So do you think that the issue with the subjectivity relating to how we determine proportionality, and also the issue that we have some states which have very wide definition of what constitutes a military objective in the first place. So the US includes war sustaining, and we saw in Syria that included against ISIS's oil fields. Do you think that given how subjective these interpretations are, that the laws of war remain fit for purpose in their current form?
Right, so a bundle of very big questions there. I mean, first of all, you referred to a term of art, a non-combatant casualty cutoff value. So this is something that a number of NATO militaries employed for a decade and a half. And what this is essentially a particular number, say 10, of civilian casualties that, if anticipated, if those casualties were expected from an attack on a military objective, then the attack could not go ahead. So it's not actually a statement of law. It's not a legal term. It's something that's part of the rules of engagement, but it's a way of trying to enforce. It's a mechanism within the military of trying to make sure that the principle of distinction is adhered to, and particularly that there is some ongoing rule of thumb for the proportionality calculus. And if we look, I mean, you mentioned the wars against ISIS, so viewers will remember this really appalling set of atrocities committed by ISIS in Iraq and Syria, and indeed elsewhere in the world. An armed group which didn't seem to abide by any of the rules of war, a really fearsome opponent. But during the wars against ISIS, the non-combatant casualty cutoff values employed by the US and by other NATO militaries were usually in single figures. For many years, they were actually zero. Attacks could not go ahead if there was a fear that a civilian could be killed. And for the highest targets, the figures went up to maybe 30. There's some indication that the attack on Osama bin Laden had an NCV of 30, although that was classified, that was confidential. So that's the range that the US and NATO militaries were employing. Now, if you look at Israel's campaign in Gaza, it appears that they are actually using an idea or have a tolerance for civilian casualties that is completely off that scale. I looked in particular early in the conflict at an attack on the refugee camp in Jabalia in northern Gaza, where Israel, they disclosed what the military objective was. So you could actually look at what the potential military advantage was. And it was attack on a middle-ranking Hamas commander. And for that, they launched a massive attack, including probably two 2,000-pound munitions, which killed something like 120 people. And they must have known in a densely populated area like Jabalia that was going to be the likely civilian harm. So we saw an understanding of proportionality, a use of the proportionality rule, which was completely out of scale with what certainly the US, definitely the UK and other NATO militaries employed in over 2 decades in the wars against ISIS and Al-Qaeda.
Yeah, and it's interesting to see that a lot of the international law blogs at the time were having the debate about whether this could be called a disproportionate attack or not. And I thought it was really interesting that I don't think that we would have had the same reaction, especially in the international blogosphere, had it been a Russian attack against the Ukrainian refugee camp.
Yeah, so I mean, I think you're right. I think there is clearly, this has always been the case. I hasten to add, I don't think this is new. It was definitely a feature of the Cold War, where people effectively applied different standards to different conflicts, depending on who the adversaries were. What I think is interesting, though, if you look at the debate over Israel's tactics in Gaza, is that there is an active debate about legality, and that the Israelis are actually part of it.
Yeah.
Israel has legal teams. I always say that when Israel goes to war, it brings its lawyers with it. And you may say, well, that's just to justify, or that's maybe to gloss over what they're doing. But it means that there is an argument. It means that what is legal is contested, and that in itself functions as an important potential constraint on military action in order to protect civilians.
Definitely. I definitely agree with you on that. So I wanted to ask as well, very recently we had a Commission of Inquiry report come out and say from the UN's Commission of Inquiry that genocide is taking place in Gaza. And it listed that the 4 acts under the Genocide Convention, along with the specific intent for those acts, had been fulfilled. So I wanted to ask, in terms of international courts and tribunals enforcing the laws of war, what could you comment on the likelihood of success of South Africa's case against Israel, and also about the International Criminal Court's arrest warrants against Netanyahu and Putin?
Right. So South Africa's case before the ICJ against Israel concerns the Genocide Convention. And the Genocide Convention is not part of what we know as the laws of war or international humanitarian law. It's a separate treaty. And genocide can take place in peacetime as well as in wartime. And I think it's interesting that South Africa decided to take Israel to court on the genocide charge rather than under the laws of war. And the reason it did it was because the ICJ basically wouldn't have had jurisdiction over Israel vis-a-vis the Geneva Conventions, because the Genocide Convention has what's known as a compromise clause or a compromissory clause, which says that the parties to the convention can take their disputes to the International Court of Justice. But the Geneva Conventions, the laws of war, don't have that clause. And therefore, many people believe it would have been better to take Israel to court, if possible, for violations of IHL or the laws of war, but it couldn't happen. And therefore, South Africa chose the Genocide Convention route, which is much harder to prove, because you have to prove not just that many people were killed, not just that various other acts took place, but that it was done with the precise intention, the specific intent to destroy Gazan Palestinians as a group. And that's a very, very hard thing to prove. And although individuals have been convicted of the crime of genocide in the past, the ICJ has never found a state as such responsible for the crime of genocide. And for that reason, I think early on in the case, a lot of international lawyers were skeptical as to whether this would succeed. I think as time has gone on, and we have seen the scope and the scale of killing in Gaza increase, and also in particular tactics like the deliberate imposition of conditions of starvation on Gaza, I think the chances that the ICJ may make a finding of genocide have definitely gone up. The important thing is that it has already imposed provisional measures on Israel to say that Israel has to allow in aid, it has to cease violations of international humanitarian law. So in a way, in terms of preventing further killing, the ICJ has already done what it can do. And I always say to people, well, what more are you going to get from this case? It doesn't stand or fall on proving a case of genocide. What we have to do is to prevent future killing. And for that, you need to also focus on violations of the laws of war, including, of course, this use of starvation as starvation of the civilian population as a method of war. So that takes us to the ICC case, to the International Criminal Court case, which of course is a case against individuals, not against the state as before the International Court of Justice. So before the International Criminal Court, we currently have these arrest warrants outstanding for Netanyahu, the Israeli Prime Minister, for Yoav Gallant, the former Defense Minister, and there were also arrest warrants for senior Hamas commanders, although we believe that all the three that were targeted have now been killed. So what's going to happen to these cases? Well, we are seeing an international struggle led by the US and Israel to try and penalize effectively those involved in the International Criminal Court, including judges and senior officials, a really unprecedented attempt to try and interfere with the wheels of international justice. But those arrest warrants still stand. And interestingly, they include violations of the laws of war, including the starvation crime that I mentioned earlier. And there is considerable evidence, apart from anything else. Senior Israeli officials, including the Prime Minister, the Defense Minister, and the President, all referred to the need to place a siege, a complete siege, no water, no electricity, no food, on the whole of the Palestinian population. And that is very compelling prima facie evidence that there was potentially the crime of starvation. So I think if it comes to court, I think there is a good chance of securing a conviction. The question is, will the ICC ever get its hands on senior Israeli politicians who are effectively under the protection of the United States of America?
Yeah, and I think going back to South Africa's genocide case, I was definitely one of the international lawyers who was very skeptical at that time. And then 6 months later, I felt like it had definitely fallen within one of the categories, which was deliberately inflicting upon them conditions of life calculated to bring about their physical destruction, given you weren't allowing in any aid and the starvation that had begun to set in. When we're looking at the ICC's arrest warrants, are you not of the opinion that Netanyahu has immunity?
He doesn't have there is this thing known as head of state immunity.
Yeah.
Which covers not just the head of state. So it wouldn't just cover the president, but would also cover the prime minister and the foreign minister. So those three figures. But this is a customary law immunity, and it does not apply where there is a specific international treaty where states have consented to foregoing that immunity. And that is the case with the Rome Statute of the International Criminal Court. And so because the state of Palestine is a member of the Rome Statute, that means that the jurisdiction under the statute, including the heads of state, is effective. So I don't believe that Netanyahu, and certainly not Gallant, would have immunity under the Rome Statute. Now, Israel makes the contrary argument. It says that because Israel itself is not a member of the ICC, that this immunity. But it also makes that argument in respect to the defense minister. And the defense minister doesn't benefit under customary international law from head of state immunity. So I think Israel's argument is essentially an argument for impunity.
Right.
And the way that the Rome Statute functions is to say there must be a point at which very serious crimes can be tried and penalized before an international tribunal. And that applies to senior members of Hamas and the other Palestinian groups who were responsible for the atrocities on October the 7th, but it must also apply to crimes allegedly committed by senior members of the Israeli government.
Okay, interesting. We've come to a point of disagreement then, because I do think Netanyahu has immunity. But going on to the rise of multipolarity in the world as well, we had a New Yorker report from April of this year that US military lawyers see Israel's invasion of Gaza and the public's reaction to it as a dress rehearsal for a potential conflict with a foreign power like China. So how do you think that the laws of war and the way they're being applied in Gaza is going to lead to a further expansive interpretation in the context of a potential upcoming war between the US and China?
Well, I think a lot of things are said, and a lot of things are said in the American military at the moment about sort of rates of tolerance or a tolerance for civilian casualties in the context of what they referred to as large-scale combat operations. And the basic argument is this, that over the last 20 years, the US has been fighting what they refer to as COIN conflicts, counterinsurgency conflicts, and that if you had a fight with a peer adversary or a near peer adversary in the context of a large-scale combat operation, you would have to effectively not fight with different rules. The basic rules of the laws of war would be the same, but you would be effectively allowing a higher tolerance for civilian casualties because the nature of the conflicts is different. And I think that there are a number of things that are going on in this argument which actually are not the case. First of all, the US has fought COIN wars over the last 20 years, but they've also fought other wars. I mean, the invasion of Iraq in 2003 was not a counterinsurgency. The invasion of Iraq was a large-scale combat operation to remove the government of a sovereign state and install a new one. It wasn't a counterinsurgency. It then became a counterinsurgency, but it wasn't in 2003. When the international coalition led by the US placed a siege on the city of Mosul and an assault on the city of Mosul in northern Iraq in 2016, 2017 to retake the city from ISIS, the commander of the operation, the US commander of the operation at the time, referred to it as the largest urban battle since the Second World War. Oh, wow. This was a major, large-scale combat operation. It left 70% of the old city of Mosul in ruins. My organization, Ceasefire, has an office there. We now support reparation claims for civilians who were damaged, who were harmed in that battle by all sides, not just by the coalition, but by ISIS bombing, by the Iraqi security forces, and so on and so forth. So the scale was huge. So this idea that we're moving from sort of small conflicts, counterinsurgencies, to something completely different, I don't think is entirely accurate. But the second thing is that where you have conventional armies confronting each other, you don't actually have the same difficulties, or you might not have the same difficulties, where there is a counterinsurgency conflict, where typically the insurgents are sheltered or are hiding amongst the civilian population. So if we look, for example, at the current war between Russia and Ukraine, the death toll is appalling. The civilian death toll is appalling, but actually a much smaller proportion of civilians have been killed compared to members of the armed forces. Yeah. Compared to, for example, the wars in Iraq and Afghanistan. So I don't accept the argument that in a large-scale combat operation with a peer or near-peer adversary, you are necessarily going to get larger numbers of civilian casualties. And I don't actually accept the argument that public opinion is less important. The bigger the conflict, the more important public opinion is going to be. And there is no doubt that one of the things that destroys public support for military operations, that outrages the public, is the large-scale killing of civilians. This is true in every state. This is true in every culture. This is true in every religious tradition.
Yeah, I totally agree with you. That's very interesting. And finally, for a final question, in your view, and again, this is a huge question, are we moving towards the future where the laws of war will be strengthened, or one where they risk becoming irrelevant?
Well, I think there is a real danger at the moment that we are seeing the laws of war under challenge. We're seeing, the Geneva Conventions, which are universally ratified. They are accepted by every state in the world, are coming under serious attack at the moment. And one of the ways in which that's done is what you referred to as expansive interpretations. And the International Committee of the Red Cross has made this a particular point. They're saying that exceptions in the law, very limited exceptions for military necessity to the basic provisions protecting civilians, have now been interpreted in ways that they eat away at the basic protection rules themselves. And that is very dangerous. Personally, I see it as a cyclical thing, that the laws of war come under attack every few decades, that it depends on geopolitical forces, it depends on prevailing conflicts. But the basic rules underlying the laws of war are not going to go away. They have been there, not just since the Geneva Conventions were concluded after the Second World War. They have been there for centuries. And when you think about it, they are actually quite intuitive. I mean, I used to do a little experiment with school children and ask them what they thought were the laws of war. And really, from elementary school age, they basically understood it because the rules are reflected in playground rules. You don't attack people who aren't part of the fight. You don't mistreat the defenseless or prisoners. This I see as the intuitive core of the laws of war, and it will remain even when specific rules or specific interpretations come under attack.
Yeah, and I'm glad you referred to, in your previous answer, the cultural and religious traditions, which really underpin and make sure that this is the law which goes back centuries. Thank you so much for joining us. This was such a fascinating discussion.
Thank you.
Thank you so much for tuning into that episode of Legally Speaking. We hope you'll join for future episodes.
Powered by International Committee of the Red Cross.